please, you bring your great buzz.
No, discombobulation. So what am I saying anyway? Okay, can I just
It's the same one from.
No, but I forgot. Yeah, so I made sure I can forget things. I'll be giving them a preview. There was a later one, I think, which had I'd moved on from Disney's.
It hasn't. The one from
QRE, consultant QRE.
Yeah, it didn't have it on the front title at that stage, so we weren't sure whether you wanted it on or not. Or
Absolutely. Do I put it on now?
What?
Put it on now.
I can't. It's a PDF.
Oh yeah, okay.
Sure. You can let everyone know now. I'm going to hand over to you now.
They might ring me then.
They might ring you. And apologies for that.
Oh, that's not all. You're fine. Where do I get my fee?
When do you get your fee? Get the sandwiches. Oh.
Hang on, I've got tissue.
Got tissue. Right.
There's an explosion.
Hi everyone. My name is Elizabeth. I've taken over from Lauren in the role of CPD. My email is elizabeth@scsi if you have any comments, queries or suggestions for the winter season. I'm going to hand you over to Hugh now for a very popular Landlord and Tenant CPD.
Thank you, Elizabeth, with Z. Isn't it? With Z? Good afternoon, ladies and gentlemen, and a very daunting audience. I see some elder lemons here, not referring to any in particular. Somebody on the way over asked me why was I doing this? And I said, well, the society couldn't get anybody good, so they asked me. And really, it's a cautionary tale about landlord and tenant, and really, if there's one message about landlord and tenant, it is that none of us have a monopoly on knowledge or about the subject. I have recourse often to call or phone a friend, and I regularly get phone calls, and I say, well, I don't know, but ask so and so, and he's not here, so just always don't ever hesitate to ask a colleague or a friend, because even now amongst the most eminent surveyors you get differences of opinion on matters of call to bank offers or whatever, or determinations or whatever. There are differing opinions, and that's what the courts are there for. And if needs be, go and get a counsel's opinion. So this is kind of a helicopter view. There's a lot of ground to cover, and I don't intend to kind of maybe deal with any particular topic in any great detail, because I've probably forgotten most of what I was going to say. So just to start with the background to rent reviews. Originally there were a mechanism to keep rents up to date with the market. If you go back to the times of the First World War, there wasn't really inflation, and people wanted security of income, like bonds, property. People were letting stuff on 99-year leases. There are still, around Dublin, there are still old leases which may be 42 years and 7-year reviews. Reviews originally, there was no reviews because there was no inflation. And then when inflation started, particularly after the Second World War, reviews were introduced to try and keep pace with the inflation. And originally there were at 7-year intervals, then 5. There was a period in the late 70s, early 80s when there were 3-year reviews, which were a madness, and I can recall CPI reviews every 3 years, and they were they were devastating for tenants, and they were unwieldy, and they just went out of practice. Lease lengths have shortened. As I say, way back there were 99-year leases. I think there were some around Dublin which are still 42, and they're still extant. More commonly now, they've dropped from 35 to 21, 20, and depending on the sector, particularly offices are much shorter. Retail tend to be about 10. Occasionally you'll get people still wanting, I want a 35-year lease. Occasionally you do get it, that for some reason, particularly tenants want them. Landlords will love them. But the lease lengths are increasingly shorter. And review pattern is settled at 5 yearly, except as I mentioned in the 70s when the 3 years were common. But again, it's down to the individual landlord and individual tenant what bargain they want to make between them. They can have 3-year review, 7-year review, 4-year, whatever they want. It's the bargain provided it's legal. And in that context, I mentioned the post-210 leases, which banned upward-only rent reviews. And I've come across a number of leases which purport to be upward-only, and they're written post-2010, and they must be read as if they are upward and downward, despite what the language in the lease says. So looking at the basis of review, again, as I say, this is the bargain between the parties. And on that subject, it is the bargain between the parties. So if somebody has a lease, that is the document which grounds everything. It doesn't matter what somebody thinks what it thinks it means. The courts will interpret it on the actual document itself. So it's the bargain between the parties. So you need to read the lease and read particularly the rent review clause, but read the whole lease, but particularly the rent review clause. What does it say? It's mostly open market reviews. In other words, the rent will be determined on the basis of a hypothetical tenant, and a willing landlord, willing tenant, on the review date, taking the property without any improvements or whatever. Sometimes you get a percentage of turnover, particularly in retail, or really only in retail, particular percentage of turnover. With the base rent, you might have 80% of the market rent as the base, and that gets reviewed on a 5-yearly basis or whatever, or sometimes, more rarely, I've done a few of them, just purely percentage of turnover. And so that's it'll be a much higher percentage. For let's say a coffee shop, it could be 15%. Some of them, maybe the major department stores, could be done to 3 or 4%, and with no base. Sometimes they're linked to CPI, Consumer Price Index, or some other index, generally CPI. I've come across and I've caused reviews to be on the basis of, because when you've got an unusual property, one case we were involved with, we said, okay, when this comes to be reviewed, you're going to have a difficulty in actually finding evidence. So we linked it to, this is going for retail units, but we linked it to office rentals in the same building. I quote the case of Peplos and St. Stephen's Green, which at one stage was secure storage, they had vaults. And again, when the lease has been written, whoever was advising said, look, we're going to have difficulty in reviewing this, because where are we going to find comparisons for basement vaults like this? So in actual fact, it's reviewed on the basis that it's as if it were first floor offices on a south-facing building on St. Stephen's Green with a lift. So it's a completely notional. Again, back to the bargain between the parties. It's up to the parties to agree what basis of the review. Sometimes it's a percentage of the market rent. For whatever reason, the landlord and tenant might want to say, okay, it's going to be 90% of the market rent, full stop. And cap and collar is increasingly common now since the 210 ban and upward only reviews. And that really means that the rent can't rise more than X percent or can't drop below. So I know of one client who has insisted on and gotten away with a 2% collar. In other words, the rent can't drop more than 2% of the from the and I think it can rise by whatever. There may be no cap in it, but it's legal. Well, as far as I know, it's legal because it actually allows the rent to fall. And even though it's kind of only a very modest amount, it does allow it to fall. So they're the basis of review. Have I gone backwards? I have gone backwards. My apologies. I have gone. Okay. So the process. Just turning to the process. You've got a lease. The client arrives into you. First thing you do is you ask for the lease. You've got the lease. You read it. You go and look at the property. So you've got to provide your client with advices. And I was chatting to somebody yesterday. I got one of those phone calls and said, I've got this situation. I said, well, that's what the lease says. That's what you need to be telling your client. He said, not your problem. You didn't write the lease. It was a particular situation where the rent review clause provided for a 15-year term, and I've had this myself in an arbitration just the other day, where the notional term is 15 years, but the lease has only got 5 years to run. So it's a madness. It's actually nonsense. And whoever wrote it, or whoever drafted the lease, thought probably they're being very clever and saying doing the landlord a favour. In fact, they're actually shooting the landlord, somewhat, because you've got to if there's only a 5-year term, you've got to discard 15. So be very careful. But in your advice to the client, it's not your job to make to make the market or to dress things up. this is what you have. So just be very careful that you're advising, it's your view, and it's based on what the review clause says. Is service of notice required? It oftentimes isn't. I know one of my colleagues in the profession doesn't serve notices unless they're required. He just writes a letter and says, look, or picks up the phone and says, we're due a rent review. If it is required, is time of the essence, or is it deemed to be of the essence? And the deeming provision can be hidden, hidden in plain sight. It might say in regard to service notice, the time is of the essence, but the deeming word has the same effect, so be very, very careful on that. So if time is of the essence, it will be construed very much, if you miss it by a day or two, you're tough, you've lost out till the next time. And likewise, if a figure is required, the notice could be invalid if it hasn't got a figure. Notices shouldn't be without prejudice. I've seen it without prejudice. It doesn't go to the heart of it unless there's a figure. Okay. I tried to have somebody's notice overturned because they said without prejudice, but there wasn't a figure quoted, and we got Constant's opinion, and the Constant said, look, because there's no figure quoted, it doesn't actually affect the notice, and it was valid. So be very careful of that. Is a counter notice required? In other words, does the tenant or landlord, whoever triggers the thing, the opposite, does the other party need to serve a counter notice and say, I don't agree with the figure, or you're not entitled to a review, or whatever? And if it's not, and are they deemed to have accepted the figure in the landlord's notice? Just be very careful on that. Then obviously there's some negotiations take place, and if in the unlikely event of you unable to agree, there's a reference to third party. Then the procedure varies completely. Generally, it's a reference to the president here in the society, who will appoint somebody from the panel of arbitrators. You may have tried to, you'll have started by trying to agree a name. Generally, people suggest 3 names, and the opposite number does the same, and you'll try and pick one of those. And if you can't, then you refer to the president. But it depends on what it says in the lease. I've come across a lease recently where the reference was to the RCS. So the people referred here, and we said, no, that's not the right party. So in theory, they have to go to London. I've seen another one which just said refer to the president. And again said to the client, well, is that Jerry Adams or Michael D. Higgins? Or again, the landlord wrote to the Gwen here and said, we want to, and well, we have no function. And unless the tenants, and which was us in that case, said, well, we're happy that the RSC, or the society appoints, which we weren't, they were stopped. There's nothing they could do. They had a flawed lease, which we'll come to in a moment. So then the society will appoint somebody, provided they're not conflicted. They take on the job, they set out directions, and then they run with the hearing. So if it's settled, generally, it again depends on the lease. But a good practice is that memoranda of rent review are prepared in duplicate. Practice varies. Some landlords prefer to sign them, send them to the tenant and say, look, it's signed, now we're going to start charging you rent on that basis. Some will require the thing to be sealed. An arbitrator's award generally, or an expert's award, is generally sufficient evidence of the review and doesn't require a memo, but sometimes people insist on that as well as having an arbitrator's award. I think we've gone through the reference to the third party and who appoints them. In terms of the appointment of an arbitrator or an expert, that's very much a personal decision. My view on it is that if you have evidence, either way, whichever, that an arbitrator is the one to go with, that if there's clear evidence, that it can be, that the only thing that at issue is how one analyses the evidence, and then an arbitrator. If there's no evidence or limited evidence, then I would think an expert, unless it's determined in the lease. Sometimes you'll find a lease, again I have one, where it's an expert. Oftentimes it's an arbitrator or an expert at the choice of the appointing party, be that the landlord or the tenant. Also, people will look at an arbitrator and say, if in a falling market or a rising market, they prefer to have one or the other. An expert will be knowledgeable in the market and say the evidence is limited or has been dated. Then somebody might say, well, an expert will be more knowledgeable, will be able to take into account the rising, falling market or whatever. So in those cases, you might go for an expert as well. Preferably a agreed party, a third party, and if you can't, you go into the third party process, which I've already outlined. So in terms of, can you all read that? The difference between the arbitration, that the arbitrator must invite evidence, and that can be oral or written. They can't rely on their own knowledge. They can only rely on their own knowledge, so that's strictly correct. They can rely on their own knowledge to interpret what's put in front of them, but they can't introduce, as I said, they can't get into the ring and say, I know something. They have to alert the people that they know of something which hasn't been put in front of them, and ask the parties, do they want that introduced, or would they go and find out for themselves? But they can't start using their own judgment or knowledge of some other action or some other lettings or whatever. They've got to just rely on what's put in front of them. So sometimes down through the years I've seen a rent, and say, well, that come from, that's kind of an enormous rent or whatever, and you find out there was an arbitrator's award, but it wasn't the arbitrator who was wrong. It was whoever put the evidence in front of him, that maybe he or she only had one side's evidence before them, that the other side maybe put in evidence that was so useless that the only award they could give was at a level which was manifestly unfair, but that was in accordance with the rules. There was no evidence put forward by the other side. So sometimes you'll see that. Just be very careful of that it's not, people blame the arbitrator, and it's not, generally speaking, isn't the arbitrator's fault. The arbitrator's actions are governed by the 210 Act, which changed the whole, it brought in the international law, the UNCITRAL law, and it conforms with that. The process is quasi-judicial. Well, it's relatively informal. It does have quasi-judicial status. As I say, the arbitrator can only decide on the evidence before them. Costs are at the discretion of the arbitrator unless they're pre-agreed, either in the lease document or by the parties. More often than not, people will agree to go back-to-back 50-50. But if they're not, then the arbitrator will determine. And generally, unless people want an unreasoned award, which is not just you get a figure, and sometimes people will go for just a figure because it's cheaper. Generally, an arbitrator will charge more for giving a reason, because in some cases these can run to 20, 30, 40, 50 pages in one case. So it will cost more to have a reason. But by the same token, the parties will know why the figure was arrived at. There is very limited scope. You have to be sleeping with the enemy, I think. Previously, there was, before the 210 Act, the courts had a role, but in the 210 Act, they have no role. I think you really would have to show there was absolute negligence or conflict or whatever to have it overturned. And even then, I quote the instance of a construction arbitration which took place over many days, and an eminent chartered surveyor, I think from the UK, was brought over. I think it was uniform in Galway, and it went to the High Court, and the judge basically ruled that the guy had been asleep several times during the arbitration. The judge basically ruled, said, look, you both thought he was asleep, and neither party did anything to wake him up. So it's a plague in all your houses, stuff. But I was reminded after the last time I did this by an eminent grey-haired member that actually wasn't the end of the story. They went to the Supreme Court. The Supreme Court said, sorry, but you should have woken. It has to be overturned, and it was remitted. It was sent back. I'm not sure to the same arbitrator, but certainly sent back. But the courts are, it's the final. The courts will not interfere. If you don't like it, maybe somebody hasn't done a good enough job. And the arbitrator can't be sued. Effectively, can't be sued. But on the other hand, the expert doesn't need to call evidence. They can just say, look, they generally do, because it's good practice, and they generally ask for evidence. But what they've got to do is they've got to use their own expertise. They must make their own investigation, not just can, but they can and must make their own investigation. They've got to go and research the evidence. Even sometimes you'll find that it's not put in front of you, but you'll have to go and find out other evidence, and also check the evidence that's been put in front of you, because sometimes the facts may not be correct. It's governed by the role is governed by common law. You don't have power of discovery. The arbitrator no longer has power of discovery. I should have said that. It used to have. There isn't a hearing generally, and no reasons are given, and the costs are predetermined in the lease. Limited possibility of appeal, but the expert will generally charge more than an arbitrator for the very reason that they're open to a claim for negligence. An arbitrator is virtually insulated, but an expert can be sued. If one of the parties thinks they got it wrong, and it's difficult enough claim to bring home, but it doesn't stop somebody from trying. But they are open to I'm going the right way, I'm going the wrong way again. So what's the role of the surveyor? I think our barrister friends kind of find this a bit amusing that we actually have two hats. We have the dual role of an expert witness, and we also have that of an advocate. So for the first part, you have your expert witness hat, you're the professional, this is your professional opinion, and then you take that hat off and you try and tear strips off your office number, being the advocate. So it's a tightrope to walk. Your role as an expert witness is to give expert evidence, to give your true and professional opinion of the rental. We presume we're talking about rental here in a rent review. That is your true opinion of the rent review. It's not what your client thinks or wants or otherwise. You have to, should sign a statement of truth. Generally, arbitrators will insist that it's done. It's produced by the society. It mirrors the RSCS statement of truth, which basically said that you have no skin in the game, that you're not acting on an incentive fee, that you have no conflict, and that you're going to give true and honest witness to the arbitration. It's the same as you would do as if you were appearing in the court. You sign a statement of truth. The role of the advocate is to literally, as I say, tear the other person apart, and there's some of the people in our profession are particularly good at that. As anybody who's been mauled by them will know, including myself. That's their role, is to go through your evidence and take it apart. And to make you, to show the arbitrator that your case is based on sand. There are various practice statements and guidance notes, and you should be aware of them. Things like zoning, measuring practice, all of that. Some of them have different standing to others. And you can, to talk about fees, which everybody loves talking about. You can have an incentivized fee in a rent review, but not if you're going to third party. What I tend to do is say, look, if we can, I'll charge you X% of whatever. But if this goes to arbitration or expert, I have to have a fixed fee, because I have to be able to sign a statement which would say, I am not an incentivized fee. My fee is a fixed amount. So other issues that come to mind, what I call non-standard leases. It is extraordinary in the last number of years, which leases which have fallen for review in like 2016, 17, 18, which obviously, and these are leases which have been written, and some of my management colleagues would probably I think see this as well. Leases which are written about from 210 on are so badly drafted, and many of them are very, very bad, and a good proportion, and it's not just some small solicitors practice and they'll go backwards and down the country. These are written by some of the major firms, and examples I've come across are, as I mentioned earlier, which isn't a bad sort of flaw in a lease, but it's having a 15-year term, notional term, and 5 years left on a lease. So the landlord's going to suffer on that. But other things I've seen is rents left out, the rent review not recited properly. It's not who's the reference to. Just completely, they're flawed. Effectively, they're flawed. So in those situations where you've got a lease which is flawed, and it's incapable of, say, you go to an arbitrator and say, well, look, I can't decide on this because I don't have a commencement date, I don't have a review date, it's not clear. The landlord's only, unless they can agree with the tenant, the only recourse is to the courts, and there's a doctrine called contra preferentum, which means that the drafting is against the person who drafted it, which is generally the landlord. So the landlord's written the lease. It'll be construed against them. So if there's a flaw, it's the landlord's problem to go and get it rectified. And then to go and get it rectified, you go into the courts and say, well, the intention of the parties was this, and if you can't produce the heads of terms, and maybe you're not the landlord that originally let the building, you're the successor, and there's kind of distressed sale, and there's no documentation, you have to go into the court and say, well, on the ordinary understanding of the English language, this is what was meant. And the judge will say, well, well, maybe it was, maybe it wasn't, but this is what I think it should be. So it's a difficult process to get a lease rectified. Sometimes you come across tenants improvements. This is, was there a valid tenants improvement notice? If there were, then it's to be valued, excluding those improvement notices. If there weren't, it leads to all sorts of arguments as to whether it should be excluded or not. The 210, post 210, again, as I say, I've seen leases which are purportedly upward only, but again, they're to be read as upwards and downwards. I don't think there's any doubt about that. Other issues which you might come across, and again I came across one yesterday, a 5-year lease. Sorry, 5-year license. 5-year license. It's called a license by one of the top firms. But the occupier had a previous lease. They have sole possession. They pay everything. They pay all the utilities. So just by putting the brand, the name license on something doesn't make it. If it's if it walks like a duck, paddles like a duck, it is a duck. And just calling it a swan doesn't make it a swan. The case many years ago was Tara Street Dart Station. I think I have the proper name on the updated slide, but this is the original presentation. It's where there was a license was created to a newsagent in Tara Street Dart Station, and several years later the occupier went to the landlord CIE and said, look, this is a lease. And so I ended up in the courts, and the court said, absolutely, you have sole possession, you have all the qualities of a lease, and none of the qualities of a license, so it is a lease. Consent and assignment. To watch for it, you've got the most recent case is Perfect Pies, which was Cafe Insane in Dawson Street, where the landlord was presumed to be acting unfairly. The landlord had wanted to buy the lease themselves, to merge it with the freehold, and prevaricated and put all sorts of obstacles in the way of the assignee of the assignment, and was found to be so. And the second one, another versus Luke, was Montagan versus Luke J. Healy Pharmacy. That was when I was involved with many years ago. Went all the way to the Supreme Court. It's where the Supreme Court eventually decided that something like 2 or 3 weeks wasn't sufficient time for a landlord to make a determination on a lease assignment. But the most recent one is Perfect Pies. If you're going to look at one, that's the Perfect Pies. But the most recent one is Perfect Pies. If you're going to look at one, that's the Perfect Pies. We've touched on contract preferential set and lease rectification. Then turning to lease renewals. Again, because leases are shorter, this is becoming more common. And in the absence of agreement, they're determined by, and presumably the tenant wants to stay on and have rights, it falls to be determined by a circuit court judge. Generally in Dublin, it's heard by Judge Jacqueline Lenane, who tends to deal with all of them and doesn't like any of the surveyors who appear in front of her. Governed by the 1980 Act, Landlord and Tenant Act, and the lease of from 5 to 20 years is up to the tenant to decide. And in my experience, you don't have to decide until the day of the court, which kind of presents a bit of a difficulty in giving evidence. If you're the opposing valuer, because you have to give evidence as to the rental value, but you don't know what term the tenant has opted for. And when it's between 5 and 20, some solicitors say it's 5, 10. It's not. It's 5, 6, 7, 8, whatever, 13, 14. The tenant can determine. And it's on the same terms as existing. So in other words, the courts are very reluctant to interfere with the lease, except if it's flawed, except there's an obvious law. I think there was a case, I think it was the Gated Theatre, which there was no insurance provision, so I think the judge, I might be wrong on that now, I think it was Gaty, but they are very reluctant to change this. Send the parties off and say, look, you have your existing lease, go in, if you have any problems, come back to me. And generally, you don't go back to the judge, except that you want to get something written in which wasn't, which would be commercial. There are some commercial terms. It's the gross rent, and it's gross rent for what the Act says is a tenement of similar character in a comparable area. So that's the evidence you've got to produce to help the judge. You've got to produce your comparisons of similar tenants of similar character in a comparable area. How is it triggered? Very important. The landlord should say, well, it may serve notice to quit, but oftentimes won't. That the landlord's notice to quit triggers the tenant's actions in serving a notice of intention to claim relief. Now, the tenant doesn't need to await the landlord's notice. The tenant, before the lease ends, usually within 3 months, will serve a notice of intention to claim relief from the landlord and say, look, we want a new lease. They don't specify the length of the lease, but just say, and if you don't give us a new lease, we want compensation of a zillion euro. And that then protects the tenant. We have a current case at the moment where we've done that, and the lease is now up. And the tenant is saying, what do we do next? I said, well, you head for the circuit court. And, because landlords oftentimes won't, they're not bothered. They say, they're still getting the old rent, and they're charging the old rent. And if there's any adjustment, and if the downwards adjustment, particularly, they're kind of saying, oh, well, look, we don't want to hear about that, and postpone the. So you go off to the circuit court, listed for hearing, and you appear before the judge, and they make a decision. So in terms of a lease renewal, there are grounds for a landlord refuting a lease renewal. In other words, saying, we're not giving you a new lease. It's rare. And there was one of my former colleagues was involved in Temple Bar recently. It's but there was a sculptor on the second floor, and the landlord said didn't want to give him a new lease. And the grounds really are, apart from the area is obsolete or whatever, is that the landlord has planning permission to redevelop the property, and is in a position, and very importantly, is in a position to carry out the work. It's not just that, I've got planning permission, and they haven't got a bob to spend on the building or to redevelop it. There was an English court case recently where which similar rules apply, and the landlord got permission to add a kind of 50 square foot extension to the back of a shop or whatever it was, and the court said this is a ruse. And they didn't give the landlord possession. They said, no, this is merely a ruse to terminate the tenancy, and off with you, and we're not giving you possession. So I think it has to be a substantial, redevelopment or demolition or whatever, and requires demolition. So and then the tenant has to be compensated, and that's assessed if you can relocate the tenant. It's the cost of relocation, loss of business in the meantime, double over is the usual. If they can't be relocated, then it's complete loss of business. So what can they prove in terms of loss of business? Some of these figures can be quite significant. I think House of Ireland is one recently where the figures are somewhere 3 or 4 million was the compensation, and they moved around the corner where the landlords wanted to develop, but the landlords didn't serve notice on them before the end of the lease. And likewise in Kilkenny shop, the landlords didn't get planning permission before the end of Kilkenny's lease, so they were stuck. They have to wait till the end of that lease to get possession. So there it's by negotiation. So you can be dealing with very significant figures where even particularly when the tenant has a lease and a valid lease, but also when they are actually in expiry. There are no rent reviews in a court lease. That's the other important thing to note, that the court doesn't actually, the lease determined by the court doesn't have actually rent reviews. The landlord has to go back, or the tenant has to go back to the court but they have to wait the anniversary of the original court hearing. So it means that the review is not 5 yearly. So if you have one now and you 1st of July is the court hearing, you won't get your lease expiry was a year ago, you're not going to get your review for 6 years. So some people will go for 7 or 8 year leases, which are really frustrating for a landlord, because sooner have your 5th year review, which is going to take place in say the 6th year, but you're back into court for the expiry again, which is very awkward for the land. That's why then that's obviously reflected in the yield. So I think landlords generally will take account of that in negotiation and try and agree something, as opposed to having a court lease. The process is expensive and uncertain. It's expensive because the poor surveyors do all the work, and the barristers turn up in the day, read the papers, and they charge 3 times as much. It's uncertain as far as you're relying on, as I described, a non-property professional being a judge. No matter how well read the judge is or whatever, it depends on the day you get them. And the evidence that's put forward, they could just, you know what you're going to get. That's the uncertainty. There is a process of appeal to the High Court, but again, more expensive, and good luck with that. So things to watch. The rent review date. A colleague of mine came across a recent instance where there was an arbitration before them, and they were actually beginning to write the award. And they had the evidence, they had a hearing, and said, I think they've got the date wrong. And it was actually turned out to be a 4-year at the end of the beginning of the first day of the 5th year, rather than the last day of the 5th year. So the evidence has been put forward as the end of the 5th year, but in actual fact the review date was the last day, was the first day of the 5th year. So it was a year out. So He couldn't do anything about it. He had to sort of go back to the buyer and say, sorry, the evidence I've heard is on the wrong date. So be very careful about the rent review date. And sometimes it's confusing about, it's confusing the last day of the 5th year, the first day, of the anniversary date. Sometimes it's badly drafted and badly couched, so just be very careful. What's the basis? Is it open market, is it whatever, or is it varied? Who's the reference to? Is it the society, is it whoever? Have your choice. Arbitrator expert, think about which you would go. If you have the choice, and you have the choice of going. Sometimes it's not just the landlord, sometimes the tenant will have the option to exercise the to trigger the review. Proving your comparisons. You will be expected to have to prove your comparisons, because you'll generally exchange a comparison with your opposite number, and they will have an opportunity to go through your comparisons and examine them, and before the day of the hearing have brought up any questions or any queries. And similarly with your opposite number, you'll do the same. But the arbitrator will expect that this is, you're not saying, I think it was that, I'm told by so-and-so that somebody else told him, Dúirt ban Lumcan, Dúirt ban LLA, etc. You've got to be able to prove them to quite a degree. Thing to watch, and there was a recent in the office, I think there's folklore now about a recent arbitration, a fairly serious one, where the topic of headline versus net effective rents came into play. Headline are all very well, but they're absolutely, they're pretty well useless in terms of a rent review. What matters is the net effective, and that is the actual rent over a period of time, be it 5 years or 10 years or up to the first break. That's up to the individual to argue. Then that's up to the individual surveyor. There are many different opinions as to how far you should go to allow for, say, the rent-free or inducements. But it is the net effective rents which are important, and the headline are almost meaningless. What is the notional condition on review? And there's a lot of case law on this as well. What does the lease say? Is it fully fitted and ready to trade? Let's say a retail unit, is it fully fitted and ready to trade? Does it assume that any incentives have already gone and been taken? So you're starting on the hypothetical rent on the rent review date, and that the tenant is ready to move in and start. Let's say again retail, they're ready to trade. What does the lease say about it, or is it silent? There's a thing called the hierarchy of evidence, which basically says that in terms of a rent review, the predominant, or the first one is the best evidence is open market lettings. The second then is rent review evidence, agreed with parties who are professionally represented. And the third, rent review evidence. Third is expert awards. You go down the line really before you get arbitrators awards. Arbitrators awards aren't much use. I'm trying to think. I think I've forgotten one. Arbitrators awards are pretty well useless because you don't know. Well, with reasoned awards you will get some idea, but you don't know what was put in front of the arbitrator to allow them to determine. So there's a thing called the Hoffman judgment, which Hoffman decided that the evidence of one tribunal is not good. The result of one tribunal is not good evidence in another tribunal. So it's not really evidence of the market. If there's no evidence of lettings, evidence of the market and quoting rents can be introduced. It is valuable insofar as it sets perhaps headlines. It says, look, it can't be more than this because that's what the market is asking. And that's generally in the absence of anything else. Another thing to watch is without prejudice. I mentioned about rent review notices without prejudice. They shouldn't be. There was a case in Dublin a couple of years ago where a solicitor went to the High Court on the basis that he was trying to rely on putting without prejudice on correspondence when he should have put subject to contract. Without prejudice is giving you protection for your correspondence or your negotiations. It's to protect your negotiations from disclosure. So you can have these discussions and they're not going to be introduced to an arbitration or to a court and say, well, look, Mr. So-and-so said so-and-so, he'd accept. So generally, you don't need, and then you don't put subject to contract and all that. Without prejudice is in for negotiations. And you see people letting brokers without prejudice, which that's a nonsense as well. It's got nothing to do. You're letting something without prejudice. It's got no function in there. And generally, if the first note has without prejudice, the chain of correspondence or chain of emails, whatever, is then covered by the same without prejudice. So other things to watch. the notional term. I mentioned, 10-year leases with 15-year notional terms. Serving notices, are they required? How should they be served? Etc. Is time of the essence are deemed? The floor areas, are they recited? Are they recited in the actual rent review clause, or are they just in the lease? If they're not in the rent review clause and they're different, then I suggest that's what's to be used. Again, arbitrators will ask you to agree. I had a case the other day where we can't agree, but what we've got to do now is, and the arbitrator always determine this in advance, is that we've got to identify where we can't agree. And if we still can't agree, then the arbitrator will just take a view and say the arbitrator cannot go and measure. The arbitrator will not go and measure. But they will dictate, you've got to say, look, that particular, we can't agree that that's 6 metres and that's 5 metres. So the arbitrator will say, look, I prefer Mr. Mark's evidence is 5 metres. Look out for the disregards. The usual disregards, goodwill, occupation, etc. And sometimes you might get unusual ones. I can't think of any immediate, but you just watch for that. Overarching principle is the presumption of reality. Like, unless it's actually set out, as mentioned about Peplo's rent review, there's a presumption of reality. Unless it's otherwise stated, you can say, well, what would the normal interpretation be, and what would the normal circumstance be? You can't just be presuming something, and again, people will try and say impute, but you can't impute something that's not actually there. You've got to look at the words on the page, and then what is reality. Watch for improvements. The hierarchy of evidence we touched on. Post-review evidence. This comes down to you've got something which happened 6 months later or a year earlier. Is it valid? What weight will be attached? And essentially, you can pile everything in. But an arbitrator will generally will adopt the view that, yes, you can introduce it. The further in time you go from the date, the less valuable. There's a court, again, I think it was Hoffman. The further in time you go from the date of the review, the less valuable it is. I think the judge actually said, just to say something, that something happened the next day, the day after the rent review, as we shouldn't be looked at, would be a nonsense. And the other rule is that if something hasn't happened in the meantime, like I quote the example 9/11, like the world after 9/11 was a different world than that before. So if you have evidence and your review date is September the 5th or something like that, and you have evidence from October, I would suggest that the evidence from October is useless because the world changed. But if things are bumbling along and there's the market hadn't changed, the economy hadn't changed overly, then something a couple of months later or 6 months later or whatever, you can introduce it. And like was from before, I had a case the other day where the only evidence I could find which was of any use, I thought, to the arbitrator was a couple of years. And my officer said, well, this is years old. And I said, well, absolutely. And I've highlighted this fact, it's a couple of years old, but it's the only thing I can find that would be helpful. So I'm introducing it with the caveat that it is dated. So there are things to watch. Turning then to the beloved theme of periodic tenancies, which is an absolute minefield. Like the whole thing of landlord tenant, I think you have to be terribly cautious with. And with reasoned awards now, I always caution people, there's no hiding. Because an arbitrator, if I'm writing a reasoned award, or an arbitrator is writing a reasoned award, I'll try and save people's blushes, or people's blushes will be, the arbitrator will try and save people's blushes. And they're not going to hang a colleague out to dry. But sometimes, no matter how nicely you phrase something, that Mr. Murphy made bags of it, it'd be very clear that Mr. Murphy was ill prepared and made bags of it. And your client will not be, Mr. Murphy's client will not be best pleased. So there's no hiding. But again, with periodic tenancies, it's, the lawyers will differ. I've seen major firms correct their advices on periodic tenancies. It's one where, if you're in doubt, go and talk to a lawyer and even go and get a brief senior counsel. It's not very expensive, generally they're not, and I would tend to go to the 3 or 4 seniors, Gavin Ralston, Owen Hickey, and 2 others who are good, who are chartered surveyors, so they have a background in property, and will give you they'll have direct access, and you write them a brief, or get the solicitor to write them a brief, because it is a minefield. Basically, a periodic tenancy is what happens when the lease expires, the tenant continues in occupation, and the landlord doesn't do anything about it. So it commences the day the lease expires. It can only be terminated, and now I should caveat, I'm not an expert in this, I have some knowledge of it, but just big approach to caution. This is my knowledge, my understanding. The only way you can terminate a periodic tenancy, and a periodic tenancy, well, generally we regard them as annual, but it very much depends on what the lease says. If the lease says it's £30,000 a year, then it's an annual tenancy. But if it says it's so much a month, then it's a monthly periodic tenancy, or it's so much a week, it's a weekly periodic tenancy. But let's say it's an annual periodic tenancy. The original lease was for so much a year, for whatever number of years, and it's expired. The landlord can only terminate it by serving notice on the tenant. And it's very important. The timing is extraordinarily important. It's a half a year's notice. It's 183 days, not 6 months. And it has to land on the day, the anniversary of the date of the lease commencing, which is, let's say, the lease around 31st of January. The period of tenancy starts on the 1st of January. So it's got to land on the 1st of January. So it has to be sent 183 days. Google, great for that. You look up Google, 183 days before the 1st of January, and you serve it on that day. It has to be. It's quite strict. And the case is Mila from Walsh. It's an Irish case. And then that gives rise to mains rates. I don't know if anybody, I was involved in one case in the High Court with mains rates, which were a tenant had overheld periodic tenancy. The judge allowed them to go, and we were back in to determine what, mains rates is what, I think it's feudal, it goes back to feudal times. It was the loss to the landlord of the right to earn an income from the land. In other words, it goes back to farming, and that, the buyer of the land has moved on into occupation, has his cattle on it, so the owner of the land can't actually gain an income. And it's the same with the landlord. It's equated to rent, but it's actually not. It's not, strictly speaking, it's not rent. It's the loss to the landlord of the use of the property. That's called mains rates, but again, sort of a bit of a minefield. And it's an unusual one, but it does crop up. Coming to an end. Right. Some reading, essential reading. If you're going to get involved in rent reviews, Reynolds and depending where you're from. Royal Lavelle calls it Featherstone Hall because our Featherstone Hall is in Portlaoise. The English call it Fanshawe. It's a big tome. It used to be called Reynolds and Bernstein or Reynolds and something. The other two are very, very good. And if you're just going to go for two, go for the two. The Surveyor's Handbook and the Case in Point, and they're from RCS Books, and they're small volumes, but they're very, very good, and they're kind of like a Bible. You should have them to hand. In terms of case law, there's case law and this is just kind of a high-level view. Don't ask me questions about them, please. Hines Independent Newspaper, an Irish case, is time of the essence, and Starrock is a UK case. Calderbank was actually a divorce case, which is the sealed offer. That's about costs in arbitration and in court proceedings. And there was a disagreement here back in December when there was a CPD on, actually in the Alexandria, about costs in arbitration, and there were two eminent people, one a surveyor, one a solicitor, as to whether, I didn't even cover Calderbanks, did I? Calderbanks is a sealed offer where you make an offer to settle, and it's given to the other side. The arbitrator is given an sealed envelope, but not open. It's like giving the judge a sealed offer, and then when they make the award, he opens it and says, okay, the landlord won because the landlord offered to settle this at less than the figure I've awarded. So the tenant has lost. Essentially then, the arbitrator will call for submission of costs. And the landlord's valuer will say, look, I clearly won. I want the tenant side to pay all of your costs, and I want all my costs from the date of making the offer to date. And generally, the arbitrator will find that. So you use sealed offers or callbacks at your peril, because they can be turned against you. Just a warning, they can be turned against you, and you might end up costing your client quite a lot of money. Macy and Tyler goes back to the 70s, the case in 24 Henry Street, 25 Henry Street, was where Macy's let this basement of 25 to Tyler's, Tyler's left the basement of 25 to Macy's. Could the landlord be also the tenant? T-Trade and CIN Properties is the notional term. Canary Wharf is the presumption of reality. Co-op, Wholesale and National Westminster, the headline rent. Plinth, sometimes called the Motte, and that's restricted use of the Motte were, and still are, I think, a firm of consulting engineers. And the rent review clause provided for the rent to be determined on the basis of the user being that of a consulting engineer's office, and so it was determined. So you should be very careful about that as well in drafting and in interpreting. Other ones: Broadgate, headline; Scottish Amicum, headline; London Lease, notional condition; Landlord and Consumers Restricted User; Sagama, Penny Leroy, post-review comparables; Landsec and Westminster, admissibility, I think that might have been Hoffman, admissibility of an Arbitrator's Award; Smith versus CI, that's the one, Tara Dart. That's the one, Smith versus CI is the Tara News, lease versus license. And other than that, thank you. And I'll try and answer any questions. If not, I'll refer to my learned colleagues. And so happy to try and answer. Emphasis on the try. Good, none.
Comment on short leases, most of what you're talking about there is related to long periodic leases. But there are an awful lot of, in the commercial space particularly, the residential is fairly prescribed, the rules are set out by the RTD and the Residential Tenancies Act. But in the commercial space, there seems to be a little bit of a confusion about what happens in terms of determination of what's been based on bad contracts. But what I'd like to know is, there was originally, going back to my beginnings, it was a 5-year, so we got a lot of 4-year, 9-month leases, which had a determination date at the end of the 4-year, 9 months. And then it could get into a rent agreement for the tenant to stay on. And then the renunciation would be challenged. You said, well, actually, we're staying on for another 5 years. So have we actually been there 10 years, or have we only been there? And I'd love to have some comments on that.
Okay, well, I suppose going back even further, I kind of call it the 2-year 9 months, which is, it was 3 years and then 4 years. Well, I suppose the basic thing is if a tenant is an occupation commercial property for more than 5 years, they're entitled to between 5 and 20. So that's a simple fact. If they've signed a deed of renunciation, then that's it, game over, they've got to go. I have a situation where somebody did that, signed a deed of renunciation, the landlord renegotiated, has given them a 5-year license. All right, now that's an interesting question. What happens then? Yeah. I don't know. Well, you don't need them with the short lease. You don't need a deed of renunciation with a lease of less than 5 years, because you don't have rights. Now, if the tenant is intending to stay on, if the landlord wants to, or if they're mutually agreeable that the tenant should stay on, that the landlord should either kind of get them to enter into a long lease, or get them to sign a deed of renunciation if they want to get it back in the future, or if they want to whatever, if they want to have control.
If indeed the renunciation clause is clear out in the contract, that would be okay.
No, but that can come in. It can come in at the end of 4 years 9.
Yeah.
They can now say, look, we'll give you another lease, but you're signing a deed of renunciation, and provided they take legal advice. They must take legal advice to make it valid. See, I'm only really dealing with interviews, that's why I didn't probably come up with such.
That is a big caveat on it, right? Under the deed of renunciation, and if it is put as a clause, they have to state who they got independent legal advice from.
Correct.
So you can't just have your tenant go and do, you having your license or your lease, and it doesn't matter when is a lease a license and when's a license a lease, like that is the theory. But you have to have that you as a tenant agree that you've got independent advice
from a named solicitor, yes.
Yeah. And you can do it by deed, or you can do it as a clause in the lease, but it is very important that they have received independent third-party legal advice. If they haven't, they have all the rights.
But this is currently, and the contract is really, really weak. I don't actually think they have a signed contract. It's a mess for lots of reasons.
But are they in occupation more than 5 years?
No, it's a short lease, but it's now expired. It's a very, very difficult situation because they're arguing for a rent review, so the landlord's intending the tenants.
But you can't have a rent review unless you've got a lease.
Well, my point exactly.
Yeah.
Well, then you just serve a termination notice.
Serve notice to quit if you're a landlord.
Yeah.
So we have drifted a little bit from rent reviews per se.
Yeah.
Louise, were you?
I was just going to say, why do you say that leases have been badly drafted since 2010? Were you sort of saying prior to 2010 they were well?
I I don't think it was just like we like rental. We all like I previously said, like we all kind of lost the art of our Landlord and Tenant because for several years we didn't do rent reviews. I don't recall. I was in the High Court once, I think, in 30 years on a badly drafted lease, which was in the country where the solicitor produced it was effectively a flat lease for a commercial property with 21 years, no reviews. Not just me, in my former existence. I started to put them together, and colleagues would come and say, "Look at this one, look at that," and it never before came across at Lease. I'd never become. There were so many of them, and it's extraordinary. You would think that it's because people, would be more careful, but they weren't. They're shockingly bad. They would have just got better. No, this is the shocking thing that you'd expect that during that period. But I think what might have happened is that the lawyers are too busy, and that this stuff has been drafted by maybe juniors or something, and they just cut and pasted, and you see an awful lot of cut and pasting, and stuff has been left out, or stuff has been missed. It was genuinely shocking. I actually started to accumulate them. I got to 12 or 15, and they're still there. Got downstairs, and the guys might will show you them. It is really frightening that, one example, 10-year lease. It was a re-gear of an old lease, and the rents were recited. There'll be a review in the 7th year, and the rents for year 1, 2, 3, 4, and 5 are silent for years 6 and 7. So there were 2 leases, two different tenants. Neither of them had the rent for years 6 and 7. Right? Now, if the tenants had ceased to pay the rent, in fact, the tenants kept paying the rent as of the 5th year. But if they hadn't paid it, the landlord would just have to go off to the court and say, "Look, judge, the lease is silent." Like that lease didn't have a willing tenant. So it had an expert, which is the RCS in London. It had several things in it. That's only one of them. So that's where the tenant tried to trigger the review. We were quite happy to sit back. And they sent it in here and said, "No, sorry, we don't, not the party, so go to London." And it didn't have a willing tenant, and it had all sorts of other flaws in it, which suited some of them suited the tenant, some of them suited the landlord. But that's only one. There was lots of examples, like things of, the 15-year term with 10-year and a 10-year lease. It's like from the landlord's point of view, it's not good, because the value is going to be arguing for a discount, whatever discount is going to be, because who's going to take a 15-year lease with on a 5-year term? So I don't know the answer, but it is. We'd never experienced it before. We did come across fraud, but nothing to the same extent. Hi.
With that 15-year lease, 5-year actual term remaining, what sort of discounts would you apply?
You're not going to get me in that one. David Potter did once. I actually meant to mention that. That's really down to the individual surveyor. I had that question asked to me yesterday, and I said to them, "Look," they were saying, "Oh, look, it's only 5 years." I said, "It's not for you to make the evidence. This is your client's lease. This is your landlord's lease. That's his. That's what you've been given. Not for you now to try and argue differently. But you've got to, in my view, you've got to discount it. Now, it's up to the individual surveyor to say, what is that, 5, 10, 15, 20, whatever. But you have to have some logic for it. There has to be some basis. There has to be, can't be just going, finger in the air, exactly. Or you can't, like what somebody did the other day, and I'll tell you when the arbitration awards out, somebody tried to argue that the reality was there's only 5 years left in these, so why are you looking at 15? But it's in the rent-year clause. Hypothetical terms that the unexpired term or 15 years. There never was 15 years, which is bit mad. But no, it's down to the individual. Like I'm not going to. I've done it, and you can ask David Potter what I said. I can't remember.
Is there a growing tendency now, or has it changed at all, for putting agreed floor areas in leases and in the entry clause? Because that's obviously an area of contention.
Yeah, and sometimes they're wrong.
Yeah.
But you're stuck with it.
Yeah, but are they coming in more often than they used to?
No. I think it's my retail's my bag, forgive the pun. I think this might begin to happen with offices.
Yeah.
Well, and again, what's happening is you're getting specialists in Although I've one now where the landlord's getting specialists in to measure kind of a pretty, mundane outlet, a retail outlet. It varies completely. It does solve a problem down the road, that this is your area, and
It's
it
quite
is.
important though, if you're trying to do a rent review, if you're valuing it on a rate per square.
Of course, it absolutely what everything generally is, yeah. Okay.
That is absolutely critical.
Well, are you happy then that your areas are recited in the rent review clause for now till the kingdom come, and if somebody comes after you and says, look, you got that wrong? I think that's why people are reluctant.
I can measure properly.
Well, can we measure properly? I would hesitate to. That's why professions are used for measurement. So the building surveyors there are guys in the UK. The building surveyors are often used for that purpose. Yeah, and it avoids the argument, but it's a cost. It's a cost. Yeah, okay.
I was just wondering, what happens when the two parties are trying to decide between expert witness and arbitration?
No, it's usually it will be one of them will usually will determine. It usually will say at the option of the landlord or at the option of the party causing the reference. So if sometimes it's the landlord, sometimes it's the tenant. So whoever's doing it, generally it's in the lease.
Okay.
But again, it could be silent. Sometimes they're silent. Yeah. So if there'd be no further, thank you all. You're paying the way out, by the way. Oh, how are you?
I'm going to turn off this mic.
Oh, it's the brother of the last day. How are you?
I know, I meant to come down, I was when we met that Steve, yes, I'd love to hear it. What? Ron Kelly.
Oh, you did?
I got to come down as well. No, we get them separately, and oh no, you take it on. And then it's well done.
Sorry to interrupt. I just got that.
No, I was going to be home.
Thank you.
The rent was reviewed at 13, but the current tenant never signed the lease. Okay?